Good evening. Scott is on assignment. I'm Charlie Rose. The United States Supreme Court is taking up one of the biggest cases of the 21st century. The justices will decide whether same-sex marriage will become the law of the land. At issue, does the Constitution's guarantee of equal protection under the law mean gay couples have the same right to marry as straight couples? Here is our chief legal correspondent, Jan Crawford.
The announcement that the court will decide once and for all the issue of same-sex marriage reflects how dramatically the law has changed, beginning in 2003, when the justices struck down laws in nearly a third of the country that made homosexual sex a crime. Today, just 12 years later, 36 states allow lesbians and gays to marry. The justices now will look at states where same-sex marriage remains illegal. An Ohio-based federal appeals court all but forced their hand. It ruled in November that same-sex couples had no constitutional right to marry. This was in direct conflict to other appeals court rulings allowing same-sex marriage. Justice Ruth Bader Ginsburg late last year signaled the justices would only take up the issue once a lower court upheld a marriage ban.
But when all of the courts of appeals are in agreement, there's no need for us to rush to step in.
Many say the justices have already paved the way for this case when they ruled 2 years ago that the federal government must recognize legal same-sex marriages. Dissenting from that decision, Justice Antonin Scalia said the court had made it easy, inevitable, for lower courts to take the next bold step and strike down state laws that banned same-sex marriage. But it's not inevitable that the Supreme Court will take that step, and Charlie, the stakes are huge. If the justices rule there's no constitutional right to same-sex marriage, well, that would throw into question marriages legalized in many states by those lower courts.
Jan, thanks.